Greetings, students. Hope you are well and safe. Today's going to be a discussion, sort of a short lecture on chapter 4 in your textbooks, pages 90 to 119. This chapter deals with civil liberties. I'll give you, a description, a definition of civil liberties. It's important, of course, that you do read the reading assignment that I have emailed to you previously. I think we'll get through this different kinds of instructional delivery. You know, I'm a face-to-face instructor, so we're going to try to do it online now, and hopefully you'll meet me halfway, and we'll be doing okay and finish out the course. The first thing I want you to note is be sure to read page 98 in your textbook. It deals with the Bill of Rights. There's a nice little chart there, and I would recommend that you deal with and understand the first 10 amendments. One of the important things to know is that, of course, the Bill of Rights were finally added in 1791, December 15th. For some reason, the founding fathers, the framers of the Constitution, forgot to add the first 10 amendments that are collectively called the Bill of Rights. One of the important things to remember is that on page 98, it gives you a short description of the Bill of Rights. I want you to pay close attention to the amendments there. I'll be discussing the First Amendment, the Second Amendment, the Fourth, the Fifth, the Sixth, and the Eighth. Also, near the end of my presentation today, I will cover Amendments 9 and 10. It's important, like I said, for you to secure the textbook. Some of you might have not bought the textbook, so I think now it's real important that you get a hold of a textbook somehow. I know you're creative in acquiring those kinds of things, as far as maybe an ebook or maybe even a hard copy of the textbook. The first thing we're going to tackle that's dealing with an important concept as far as civil liberties is on page 101, and it deals with selective incorporation. One of the important things is that selective incorporation, sometimes students have a difficult time understanding the selective incorporation process. One of the important things to remember in dealing with the selective incorporation process is that when the Bill of Rights were approved, they were only applicable to the federal national government. They did not apply, they were not applicable to the states. So therefore, a process had to start to incorporate the important amendments in the Bill of Rights to be made applicable to the states. And the important amendment used by the courts was, of course, the 14th Amendment. So if you take a peek in your textbook on page 101, you can see that Gidlow versus New York is the first Supreme Court case that deals with freedom of speech. A brief explanation about Gidlow versus New York. Gidlow versus Mr. Gidlow was, of course, in the capital of New York, in Albany, and he was really sort of protesting the government of the United States. And so he was arrested because the state of New York said he did not have the right to do that, to really sort of deal with the bringing down of the government. He did not have that protection under the First Amendment because the First Amendment, freedom of speech, only applied to the federal government. And Mr. Gidlow was doing his speech in the state capital. So that dealt with, that jurisdiction was the state of New York. So what's going to happen then, this case reaches the Supreme Court of the United States, And the Supreme Court agrees with Mr. Gidlow, saying that he should have been protected by the First Amendment, freedom of speech, and therefore this case is the first case that selectively incorporates the Bill of Rights, First Amendment, to be made applicable to the states. Followed by that, there will be other cases. Another one that I'll mention is Neer versus Minnesota, 1931, that deals with freedom of press. This also follows the pattern that Gidlow versus New York did, and then this case, the Supreme Court also federalizes or nationalizes the freedom of the press to be made applicable to the states. The third example is Dijon versus Oregon, and this is a 1937 case, and this deals with the right under the First Amendment to assemble. Again, the Supreme Court uses the 14th Amendment, and its decision allows for the selective incorporation or federalization or nationalization of the freedom of assembly to be made applicable to the states. So I've given you three examples how the selective incorporation process works. One of the important things to note is that not all the amendments of the Bill of Rights have been made applicable to the states. For sure, there's, for instance, Amendment, one of the provisions in the Fifth Amendment, the right to a grand jury trial is not applicable to the states. So therefore, there are certain amendments that have not been federalized or nationalized under the selective incorporation process. So I want you to, of course, take note of that. Now we're going to deal with, like I said, I'm going to review and explain some of the important amendments dealing with the Bill of Rights. And of course, we start with the first one, which is the First Amendment. The First Amendment is really freedom of expression amendment, and it has a lot of other areas that is covered by the First Amendment. So in dealing with the First Amendment, we deal first with the freedom of religion. In the area of freedom of religion, we have two important areas that are covered under freedom of religion, the First Amendment. The first area or sub-area, as far as freedom of religion, is the No Establishment Clause, which says that the government cannot have a state or federal religion. So government should not be directly involved with any kind of religious practices or ideology. The second clause in the freedom of religion area of the First Amendment is the Free Exercise Clause. The Free Exercise Clause deals with individual freedoms that individual citizens can practice the free exercise of religion. This is not an absolute right. What happens here is that, for instance, you can practice any religious denomination that you choose, but there are certain limitations. For instance, you cannot use drugs in religious practices. You cannot be engaged in polygamy, having more than one wife, and you cannot deal with human or animal sacrifice. So those are some of the limitations that are covered under the Free Exercise Clause of the freedom of religion under the First Amendment. So we have covered the first important area, freedom of religion under the First Amendment. The second area that I'm going to cover, and one that is very important also, is dealing with freedom of speech. In the area of freedom of speech, again, remember these freedoms are not absolutes. Always keep that in mind. So in the area of freedom of speech, we have a lot of sub-areas. For instance, we have in the area of free speech, clear and present danger, which means that you cannot be, for instance, as an example, in the free and present danger clause, you cannot yell fire in a crowded theater. You would not be protected under the free speech, clear and present danger clause. So one has to be careful about that. The second area is dealing with freedom of press. And of course, freedom of press is very important to us. We don't want the government to suppress our freedom of the press rights. So one of the important things that we have to be cognizant of in the freedom of the press area is prior restraint. So the government cannot stop us from publishing certain articles or publications. We have to be careful there because the government could maybe censure us if we were dealing with national security issues. So one of the important things is we have to be careful that we don't reveal any military kinds of secrets that are going on with the U.S. military. So prior restraint can be used by the government in that example. The next area under freedom of speech is symbolic speech. Now, under symbolic speech, what we have going here is, of course, can someone wear an image, a sign, or a symbol in protest of something that's going on in the society, in the U.S. society? The best example of symbolic speech, it would be a case in Tinker versus Des Moines. Tinker versus Des Moines was an important case that happened in 1965, and there was a couple of high school students that were protesting the war in Vietnam. So they tried to go to school, and they were wearing the black armband. The principal at the high school met them at the door and said they could not come in because that was not allowed, to wear a black armband to protest the war in Vietnam. So that case reached the Supreme Court of the United States, and the Supreme Court of the United States ruled in favor of the two students and said that the students should have gone to school and should have not been stopped by the principal at the school door. The Supreme Court said that the school was saying that if the students were allowed to go to school, there would be violence by the other students upon the Tinker brothers. But the court said that that did not happen because the students weren't allowed to go into school. So, symbolic speech is protected under the First Amendment. The other example, besides the Tinker example, is the burning of the United States flag. Sometimes I know that maybe 90% of the American people really hate that kind of activity. But the Supreme Court of the United States protects that under the symbolic speech area and says that the burning of the U.S. flag is legal. We might not like it, but it is legal under the symbolic speech area of the of freedom of speech of the First Amendment. The next area I'm going to cover is libel and slander. Libel and slander deal with, can a person, for instance, libel somebody, an individual? And libel is written. So if you're going to publish something that libels a person, you have to be very careful. Otherwise, you could be in jeopardy of being sued. Let me give you an example. If people write something about you or me, we are protected more because we're individual average citizens. Now, if we were celebrities, like maybe Taylor Swift or Kim Kardashian or LeBron James, then we would not be protected as much under the libel area of freedom of speech. So we have to keep that in mind. Average citizens are protected more than, of course, celebrities or even elected politicians. The other area dealing here with the area of libel is slander. Slander is, of course, deals with oral or verbal expression. And, of course, this area, somebody would slander an individual will defame a person's character. So we don't want to do that verbally or orally. And so, again, the celebrity status applies. People cannot slander you and me we are protected more than those celebrities, as I mentioned before, like Miss Taylor Swift or Kim Kardashian or LeBron James. The next area dealing with speech is hate speech. Now, hate speech deals with hatreds toward racial, ethnic, gender, or some other sexual orientation group. So we cannot go ahead and express our hatred for these kinds of groups. Those groups are protected. They're protected groups under the hate speech area. The next area is fighting words. Fighting words, of course, deal with expressions that could lead to maybe violence or disruption of the peace. So we have to be careful in using those kind of derogatory words. The next area under freedom of speech and expression is pornography and obscenity. Pornography and obscenity has an important Supreme Court case. It has a case from California. Specifically, it was Miller versus California, 1973. And in that case of Miller versus California, 1973, the Supreme Court said that it cannot decide for the American people what was going to be pornographic or obscene. So the Supreme Court in that decision of Miller versus California established community standards. So for instance, New York, El Paso, Las Vegas, Dallas, all the communities that I mentioned, it was up to them to establish their own community standards. So that's the way it works as far as pornography and obscenity. A very important case you need to, of course, follow up and, of course, get more information on Miller versus California, 1973. The next area, also dealing with freedom of expression, is the freedom of assembly. And, of course, that case and that area is protected by the Supreme Court, as I mentioned decisions earlier. And so one of the important things to remember is in dealing with assembly, we have to get permits in order to assemble. If we're going to, have a parade or have a gathering of our large group of people, we would have to get a permit. So one of the important things there, as far as freedom of assembly, is to get a local permit from local government entities. So that concludes my discussion on the First Amendment. And like I said, the important thing is to read the important areas in your textbook dealing with the areas that I just covered. And again, these areas start with page 98 to page 109. So be sure to cover those later on. Of course, not right now because I'm talking to you and discussing those areas now, but later on, be sure to cover those because you're going to be tested on that. The next area that I'm going to cover is the Second Amendment. The Second Amendment deals with, of course, the right to bear arms. It's a very important amendment. A lot of people in the United States like that amendment because it allows people to, of course, have the right to have rifles and guns and all kinds of things. I of course, am not a proponent of having too many of these kinds of guns and semi-automatic rifles. I think the framers of the Constitution were talking about militias, state militias, but the present-day interpretation of the Second Amendment is that individuals have the right to bear and carry arms. So we have to be careful with that kind of situation. Let's not overdo it. I mean, a rifle, a gun here and there for protection and hunting is okay, but let's not go overboard with assault rifles and that kind of thing. That's my personal opinion. The next area I'm going to cover is, of course, dealing with, this is on page 110 in your textbook. It's dealing with I'm going to skip to the Article 1 of the U.S. Constitution because Article 1 has some constitutional freedoms and liberties that are there for individual citizens. So on page 110 in your textbook, be sure to make that notation, deals with three important liberties that are there from Article 1 of the U.S. Constitution. The first one is ex post facto laws. Of course, ex post facto means after the fact, so we cannot have any laws that are in the books, and we cannot be arrested for something we did if it's not in the books at the time we did it. So there would be no ex post facto laws. That means no laws after the fact. The next area under Article 1, dealing with civil liberties to individuals, is bills of attainder. That means that bills of attainder, you cannot have a specific law against an individual citizen. It has to be applicable to the general population. So that's what we're dealing with here with no bills of attainder, that you cannot have specific laws to go after, for instance, one specific individual or citizen. The last area in Article 1 that deals with civil liberties is the writ of habeas corpus. The writ of habeas corpus is very important because sometimes people get incarcerated, put in jail, and so in this country, the writ of habeas corpus deals with, really it's a Latin term that means produce the body. So in other words, there should be no unlawful and irregular incarceration of individuals. People should be, of course, face a magistrate and given the rights to post bail and be offered bond reductions. So the writ of habeas corpus is a very important civil liberty coming from Article 1 of the U.S. Constitution. And like I said, it's going to be discussed on page 110 in your textbook. Be sure to take a peek at that. The next area I'm going to cover are going to be the criminal justice protections of the U.S. Constitution. There are four important amendments that I'm going to deal with. The first one starts on page 112. It's the Fourth Amendment. And then I'll deal with the Fifth Amendment on page 112 and 113. And then the Sixth Amendment on 113, which I'll cover then. And then page 113 and 114 would be the Eighth Amendment. So let me cover that, and then we're almost finished in my discussion of these important amendments. So let me go back to the Fourth Amendment. The Fourth Amendment deals with illegal searches and seizures. So one of the things we have to do is, of course, if police do not have a written warrant, then the police should have, or should need to do, is to establish probable cause. If police lacking a warrant, a written warrant, they do not have that, then police have to establish probable cause. And you probably have seen many police stories and television programs where the police do not have warrants and they establish probable cause. Probable cause is like maybe gunshots, screams. The police don't have to go back to a magistrate judge and get a written warrant. They can act there because they have probable cause to investigate, certainly a scream or a gunshot. The other thing police use in probable cause stops, when they stop individuals, is usually in vehicles or maybe some kind of maintenance problem or traffic violation problem. Then the police will stop that vehicle and establish probable cause because of a like I said, violation of a traffic violation or maybe equipment violation. So that would be a legal stop, and because the police have established probable cause. The next area in dealing with the Fourth Amendment will be, of course, drug testing. And the Supreme Court of the United States did uphold that drug testing is legal and permissible. And so that's an important thing to of course, to know and understand. And sometimes employers will utilize drug testing of their employees. The next area is important as far as sort of a limitation or a maybe a less protection of the Fourth Amendment to individuals, and that was the U.S. Patriot Act of 2001. This came about because of 9/11 terrorist attacks, and it allows the police and law enforcement be a little more laxed in establishing probable cause and maybe not to be, using strict adherence to the written legal document that you have to search and seize individual, lacking a legal order from the court. So that's the Patriot Act of 2001, minimizes some of the protections as far as individual rights under illegal searches and seizures. Therefore, we have to be cognizant of that. The next amendment is the Fifth Amendment. Now, the Fifth Amendment, as I mentioned before, in the selective incorporation process, has not been selectively incorporated to be made applicable to all the states. So that's an important notation that you should remember. Some of the sub-areas of the Fifth Amendment, of course, are the right to a grand jury indictment, double jeopardy, self-incrimination, due process clause, and the right of eminent domain. I recommend that you read further on the sub-areas that I've mentioned of the Fifth Amendment, especially, like I said, dealing with self-incrimination on page 113, because it specifically identifies a Supreme Court case of Miranda versus Arizona in 1966. So pay close attention to that case as far as self-incrimination. And I think you are probably familiar with Miranda versus Arizona because police will have to give you the Miranda rights in order to let you know that you have the right to an attorney, and you should probably not say too much when you're in the custody of the police. And of course, you are familiar with that decision from the Supreme Court. The next area is the Sixth Amendment, and again, the Sixth Amendment is dealing with the procedures for rights of the accused, and there are sub-areas of this, of course. Let me give you the 4 sub-areas of the Sixth Amendment. The first area is the right to legal counsel. Right to legal counsel has a Supreme Court case attached to it. It's Gideon versus Wainwright, 1963. The decision of the court in Gideon versus Wainwright allows for poor people, not having enough money to hire a lawyer, and that's the exact case that happened to Mr. Gideon. Mr. Gideon defended himself in a Florida case, and he did not have a lawyer present to defend him, and he was found guilty and sent to prison. Mr. Gideon, while in prison, appealed to the Supreme Court of the United States and said, hey, I don't think that's right for a poor person that doesn't have enough money to hire a lawyer for them to go to trial and be found guilty. The Supreme Court agreed with him, and so therefore, because of that decision, poor people will be provided with legal counsel if they lack the funds to hire a lawyer. So that's an important outcome of Gideon versus Wainwright. The second area that I'm going to mention is a right to speedy trial. And so individual citizens that are arrested hopefully will have the right to a speedy trial, and that's very important. You don't want to be waiting for a trial a year or 2 or 3 or more, so that's an important protection that you have under the Sixth Amendment. The next area, as far as the Sixth Amendment, is a right to an impartial jury. This is a very important protection. Of course, we do want to have an impartial jury to be there when we go to trial. Hopefully, we don't want to revisit the 1940s or 50s or 60s where black defendants went to trial and they usually were confronted by an all-white jury. Certainly, we don't want to do that. We want to have a jury that is impartial, objective, and hopefully made up of the individual defendants' peers. And the last area in the Sixth Amendment that's very important is the right to cross-examine witnesses. I think that's important. You need to do that. If somebody's accusing you of a crime, I would hope that you would have the right to cross-examine those witnesses. That concludes my discussion on the Sixth Amendment. The next amendment is the Eighth Amendment, and it's covered in your textbook on page 113 and 114. Uh, the Eighth Amendment is really an important amendment. It deals with protection for people that have been arrested, and it is a protection against excessive bails, fines, and also deals with cruel and unusual punishment. So, one of the important things here in the second area that I mentioned, cruel and unusual punishment, sometimes states who execute defendants, sometimes the execution, whether it be lethal injection, might go wrong, and so sometimes individual defendants, after they have gotten the lethal dose of drugs, sometimes they stay longer, more than 20, 30 minutes, and so sometimes this happens, and so the Supreme Court keeps a close eye on cruel and unusual punishment as it relates to lethal injection. The other thing that's kind of modern in the area of cruel and unusual punishment is solitary confinement. Can we keep an individual inmate in solitary confinement? And some states, of course, might overdo this, and so the Supreme Court is keeping a close eye on solitary confinement as it relates to confinement of individual inmates. That concludes my review or discussion of Amendments 4, 5th, 6th, and the 8th Amendment. The last two amendments that I'm going to cover, one is on page 115 in your textbook, is the 9th Amendment. The 9th Amendment establishes the rights of, if the states and the federal government do not have these rights, then the rights then are retained by the people. So this is a very important amendment. That means that rights not possessed by the federal government or state government belong to the people. This amendment also gives sort of the initial footing for the right of privacy. So because the federal government, state government might not be involved with privacy issues, the right of the people to be dealing with the right of privacy is one of the important contributing factors to the right of privacy. For instance, the right to an abortion, the right to the right to birth control. Those kinds are privacy rights that come to the surface because of the 9th Amendment. So it'll be good for you to go back and take a peek at the 9th Amendment on page 115. The last amendment I'm going to cover is the 10th Amendment, and that is, of course, the Reserved Powers Amendment. The framers of the Constitution said powers not reserved and not held or enumerated by the federal government then, of course, belongs to state governments and or to the people. So that's the 10th Amendment, and that discussion is on page 117. That concludes my covering of the amendments. The last area I'm going to cover before I cut off is privacy rights. And privacy rights are not mentioned, not enumerated in the Constitution of the United States, but have evolved. They have evolved from, as I mentioned, they have evolved from amendments. They have evolved from the First Amendment, the Fourth, the Ninth, and they have also evolved from Supreme Court decisions. For instance, in the area of same-sex marriage, that came to be because of a Supreme Court decision in Obergefell versus Hodges in 2015. So that decision by the Supreme Court establishes the right of individuals of the same sex to be able to marry. So that would be an example of a privacy right that was established by a Supreme Court decision. Well, that concludes my discussion and sort of little brief overview of some of the important areas of Chapter 4 for American Government 2305 students. I recommend that you, of course, review or, maybe review my video and be sure to take good notes and my reference to those reading page numbers is very important. I'm going to provide you with another video probably in a week. Today's April 1st. There's no April Fool's jokes, by the way. And so I am going to provide you another video probably in a week, which would deal with April 8th. And that would be the video on Chapter 5, which would be civil rights, the area of civil rights. Important notation for you to remember and write down is that the exam for Exam 3 is going to be on Blackboard, and it's going to be 40 questions, just like the regular in-class exams that I've already administered to you. And it'll be available to you April 15th and 16th. There will be a time, there'll be a time constraint of about an hour. So you would be, of course, logging into Blackboard, and you would take the exam, which I'll make available to you April 15th and April 16th. I wish it was October and we would be doing in-class kind of stuff, but that's not the case. It's April 15th and April 16th will be the exam. What I'll do for you also is on April 13th, I will have a review. I'll do a video review of Exam 3 content area, which would cover Chapter 4 and Chapter 5. Sort of what I did in the classroom face-to-face instruction, where before the exam I would have a review. This, of course, is going to be different because I'm going to be doing it on video setup, okay? I hope you're doing well. I hope you're healthy. And stick with it, and I'll get back with you probably in a week. Thanks a lot.